Good morning, Your Honor.
Kelly, good morning. Kelly, this is my criminal docket. I'll be honest with you. I'm not going to get to front of the court till the end of my roll call.
Okay, no problem. Thank you.
All right. We can give you a call.
Okay, sounds good.
Thank you. Will you call in the hall for Sherad Gant? Sam. All right, Mr. Hartung, what case are you on?
Today I have Michael Isaac and Sierra Gibson.
Thank you. Sorry, Mr. Fry is on Sierra Gibson and Mr. Dagger Margosian is on Isaac. So I don't have
Mr. Noe substituted in on Mr. Isaac.
Oh, okay. I don't have him either, but he'll be here. Okay. All right, Mr. Brandt, good morning to you.
Good morning.
And you are here on
Ms. Burstiaga.
all right. I don't have a Bursiaga, or is it a pickup?
Oh, never mind. Wrong courtroom.
Okay, good to see you.
Always, Your Honor. Bye now.
Bye-bye. All right, I have somebody on a Motorola device. I'm going to send you a request to start your video, please. Good morning. What's your name?
Good morning. Erica Wright.
Erica Wright. All right, I'm going to rename your screen. And your attorney is Mr. Murphy.
Yes.
So I'm going to put his initials after your name. And then I am going to pop you in the waiting room, okay?
Okay.
Thank you. Got Mr. Malaro. Hi, this is Judge Anselone. I'm ready for Israel Vela.
Already can do.
All right, thank you. Bye. Mr. Malaro, I have Aymee Clough.
Okay, Judge.
Hold on, she's kind of stuck in purgatory. There she is. We gotta get her connected to audio. Send her a message to connect to audio. Now I have somebody that's at RGC. What is your name, please? From MDOC, what's your name? I have somebody at the prison sitting in a room. Can you hear me?
Yes, ma'am.
Oh, okay. What is your name?
William Dillard.
All right, Mr. Dillard, good morning. So give us just a moment and I'm going to change your screen name. And when you have an attorney that's in the court next door right now. So when she gets done, I'll bring it back in. Okay, Mr. Dillard?
All right.
We have good ones on the Everyone Drive, okay. And then
Right.
the number is not.
Sure.
Yeah, so. Yeah, also you should get noticed.
Judge, could I do a breakout with Miss Clough?
Yeah, she's not connected to audio, so not right now. Oh, wait, she is. Miss Clough, can you start your video, please?
Yeah, I'm here.
Okay. This is in the matter of the people of the state of Michigan versus Aymee Lynn Clough, file number 25-22154FH. I have, I have Alexander Bayonetto appearing on behalf of the people. Are you my prosecutor today, Mr. Bayonetto?
Just until Ms. McClure arrives, yes, Your Honor.
Okay, and then I have Salvatore Malaro appearing on behalf of Ms. Clough. So, ma'am, Mr. Malaro would like a breakout room with you. So let me open up a bunch of breakout rooms, and I'm gonna pop you two. And I have Mr. Coast here too. Mr. Malaro, just to give you a heads up, Mr. Coast provided a letter that states that she is doing well in her participation with the Hillsdale County Family Court. She's been completely negative and made all her appointments as well as her trauma assessment.
Thank you, Judge.
Go ahead and join the breakout room, Ms. Clough. So, Mr. Bayonetto, guess what I found?
What was that, Judge?
Guess what I found?
What was that?
A Mike and Sylvia's t-shirt that I wore
Oh,
when I
wow.
worked there. in high school.
Every once in a while I'll be digging through something at my parents' house and find one of the old Sylvia's shirts.
Yeah, well, mine was Mike and Sylvia's because I'm like OG, right?
Right. Yeah.
Right.
I never knew it as Mike and Sylvia's. As soon as I started going up there with my grandma, it was just Sylvia's.
Yeah, so I was laughing. I thought that was pretty cool. All
They hold up
right,
pretty well.
They actually do. Mr. Vila, good morning. We're just your attorney's in a breakout room with someone else, so it'll just be a minute, okay?
Right.
All right, one of you have court today?
Yes.
What's your name?
Christopher Lee.
What's your last name?
Lee, L-A-T.
Okay, Mr. Murphy is your attorney.
Yes, ma'am.
So he is next door. He will be here shortly. Andrew Wright, I just brought you in to let you know, we're waiting for your attorney to get here, which is no big deal. You have Mr. McManus, correct?
Correct, yes.
Yep, and it's you're early, so that's probably why it's not here yet. So I'm gonna put his name after yours. And then when he gets here, I'll bring you in, okay?
Okay, what's the, all right, sounds good. What time was our court date?
8:30, but
court?
it's not quite 8:30 yet.
Okay.
That's all. All right, thank you.
Okay.
Okay.
All right, Miss Madrid, your attorney is, let me find your attorney. Are you Sierra Madrid?
No, I'm Sierra Gibson. Can you hear me?
Yep, I can hear you. All right,
Okay.
I'm gonna change your screen name. So it shows Gibson. And You have Brian Fry.
Yes.
So we are waiting on Mr. Fry. So I'm gonna change your screen name and I'm gonna pop you in the waiting room, all right?
Okay, thank you.
Thank you. And now just wait for drinks. All right, Mr. Malero, I will bring back Ms. Clough. Okay. Mr. Malero, how do you wish to proceed with Ms. Clough?
Judge, there's been a plea offer outstanding for a while. But Miss Aymee was in some rehab and her thing out in Hillsdale. And it's great to see her doing well. I just explained because it's been a while, I explained the plea offer to her, but she's not ready to accept at this point. But this case is pending for a while, so I'd asked to set it for trial and perhaps a bench conference in a month or so and see if we can't get this across the finish line. So that would be my request.
Okay, how about I do this, because why don't we do this? Why don't we set another pretrial for you to meet with her, and then you guys can set up a bench conference with me. And then if it doesn't get resolved at that point, I'll set it for a trial, the next pretrial. Let's go October 1 at 8:30 in the morning,
Judge, I'm not available the first week of October.
October 8th at 8:30 in the morning.
Sure.
And what is the plea offer is to plead to an attempted home invasion, third, dismiss count 2, no upfront jail, correct?
That is
That is-
correct, Your Honor.
Yes.
And how old is Miss Clough?
I want to start college. I want to start college, so that'll affect the whole deal with it, so.
Ma'am, my question was, how old are you?
Oh, I'm.
I can't hear you. How old is she, Mr. Malaro?
27,
27.
Judge.
Okay. All right, well, felonies do affect college, but not for everybody. Lots of people go to college. All right, so I'm gonna set this to October 8th at 8:30 in the morning. And Mr. Malaro, can you do the stip in order to adjourn?
Yes, Your Honor, and we'll get this figured out, Judge, I'm sure.
Okay, thank you.
Yep.
All right, and let's see, Mr. Malaro, I have Israel Vila. Let me get him. Okay, hold on, we got his files. All right, in the matter of the people of the state of Michigan versus Israel Vila Jr. File number 25-22210 FH and 25-22368 FH. I have Salvatore Malaro appearing on behalf of Mr. Vila, and I have Phoebe McClure appearing on behalf of the people. This is date time set for pre-trial conference. Mr. Malaro, how do you wish to proceed with Mr. Vila?
Your Honor, we did an exam on one of the charges, so we're gonna have the transcript. I'm pretty sure it's been ordered. I have spoken to the prosecutor, Miss Arnold. There's apparently some body cam footage there she's tracking down. And there was an issue about some substances being tested that weren't. It's now my understanding those are being sent off to be tested. So I'm pretty sure we're gonna need another pretrial.
All right, how far out? When did you order the transcript?
It's a good question, Judge.
And I can clarify some of those outstanding discovery issues as well, for the record.
Okay, which file did you do the transcript request on, Mr. Malaro?
Let me look.
It would have to be this 368 one, I believe.
Hold on, let me
Yeah,
look.
368 FH file. I'm looking to see if it's been ordered, but I don't see that, Judge, so we'll make sure it gets ordered right away.
Unless it was done at district court level. I don't like ordered at district court level. I don't have it in my circuit court files. So I'm gonna set this out 90 days for that, Mr. Malaro, because that's how much time we allow them. So November 26th at 8:30 a.m. Mr. Vila, if it gets resolved before that, or we
No,
get the
that's-
transcript.
That's fine. Keep pushing it out. Keep pushing it out.
Okay. I just wanted to let you know, if
No,
we
you
get
good.
the transcript,
You
or
can
if it
push it out.
gets resolved, I'll bring you back sooner.
You can push it out another 6 months. It's fine, man. I'm good right now.
Judge, did you say November 26th?
Yes, sir. Can you do this different order?
Yeah, that's the day before Thanksgiving, I hope.
Yeah.
It is. Judge, can I make a brief record of the outstanding discovery?
Yes.
So as to the lab results, the Michigan State Police Lab only accepts 3 items initially for testing. So the outstanding items otherwise would have to be requested for further testing, which has happened at this point. So we're waiting for that further testing to come back. It's been sent at the request of us since the last time. In addition, we are waiting for body cam footage to come in from Detective Ganter. We do not have that yet, but as soon as we have it, we will turn that over.
All right. Okay, Mr. Mallory, you do the step in order to adjourn, correct?
I will gladly do the step in order for this court, yes.
Hey, Asma, you said it's November what?
26.
All right.
All right. Thank you, Mr. Vila.
Yeah.
Wow, that was easy. All right, I like it.
Yeah. Okay, so, Mr. Mallory, hold on one second. Got Chad Stewart, Mr. Malaro, and then I think I'm done with you.
Oh, I had Israel Vela twice. Look at it. Okay, that's fine.
Chad Stewart, right? Yeah.
Yes, he usually shows up in person, Your Honor.
No, he's on Zoom today. I gave him Zoom instructions
Okay.
last night. All right. Good morning, Mr. Stewart.
Good morning.
This is in the matter of the people of the state of Michigan versus Chad Stewart. We have two files, 25-22167FH and 25-22168FH. I have Salvatore Malaro appearing on behalf of Mr. Stewart. I have Prosecutor Phoebe McClure appearing on behalf of the people. Mr. Coast has provided a letter stating that Mr. Stewart is doing well with drug testing one time a week. His last 43 tests have been completely negative. Oh, Mr. Okay. So, Mr. Malaro, how do you wish to proceed today on behalf of Mr. Stewart?
Judge, could I have a breakout with him real quick?
Sure. So, Mr. Stewart, I'm going to open up a breakout room and you're going to get an invitation to join. Go ahead and join it. And then when you're done talking to Mr. Malaro, if you can't figure out how to come back, don't worry, I'll bring you back. All right.
Okay. Thank you,
There you
Judge.
go. Go ahead and click on join. Mr. Gant, are you ready on Gant? Mr. Gant, you want to come up to the podium? Yeah. Okay. This is in the matter of the people of the state of Michigan versus Sherad Gant, file number 24-21791FH. Are you Mr. Gant? Yes, speak up for me.
Yes, ma'am.
All right, there you go. You're nice and loud. All right, Mr. Gant, we are here today on a request and summons for probation violation, which alleges that you have failed to make any payments to the court since being sentenced to 18 months probation on November 8th of last year.
Yes, ma'am.
Right? You have a balance remaining of $1,606. So do you understand if you were to proceed on a violation of probation and you were to be found guilty, you could be facing up to 5 years in prison?
Yes, ma'am.
Okay. And now, Mr. Gant, how old are you?
21.
21. And are you working?
No, I currently have a job, but I'm not working right now because of the accident I got in.
Okay, so when are you going to be released to go back to work?
I had another doctor appointment today because I got to get another surgery. So after that, that's the time.
Okay. And okay, so who do you live with?
My mom.
Your mom? Is your mom here today?
No.
No? Who's here with you today?
Just my grandma.
Your grandma? Okay, she doesn't look old enough to be your grandma. Okay. So Mr. Gant, here's the deal. You got a really good deal here for doing some stupid stuff, right? And, you gotta pay this money off somehow legally, and you gotta stop doing stupid stuff. Okay? So those pictures, that's stupid stuff, right? Do you understand? If you were to get in trouble for that, you could go to prison.
Yes, ma'am.
And you seem like a nice young man. You wanted to come in today. You're taking care of this, but you need to stop doing stupid stuff. You got 6 months. So what's the recovery on your surgery gonna be?
Probably another 3-4 months, I don't know. It depends on like, because I think they just taking the rods out. I don't know if they sawing down, chopping down on bone, I don't think so. So
Those are pretty bad cards.
yeah, it's
Oh.
just-
Yeah. Is there restitution on this file?
There was none ordered, Judge.
Okay. All right. So, Mr. Gant, other than some foolishness, you really he hasn't violated probation. He's been doing pretty well. Is that right, Mr. Jones?
This is the only thing I have in Wright County, but we need some money from him. He hasn't done nothing for us. He's reported, he hasn't done anything. else
Okay.
as far as-
Okay, where were you working before this accident?
Amazon and Pontiac.
Oh, that's right. I remember that. I think you told me that before, didn't you?
Yeah.
Okay. All right, so okay, so my advice to you is do some work for family members, do what you can do, ma'am, can you come up here with them then? Hi, what's your name, please?
So much. I could give him a little work to do. He just can't lift anything with that arm. So he's been actually looking for work. But they told him he couldn't lift more than the mug, but I could find some yard work or some stuff around the house.
What's your name, ma'am?
Stephanie Gant.
Gant, okay. Just something, he owes 1606. And if we can get that paid off, we'll cut him
We
loose.
could leave about 200 today to start it. Would that be good?
Yeah. And then if he can get that paid off, he'll be done with probation.
Okay.
Okay?
Judge, if he pays off before the end of the term, I'll submit it to the court.
Yeah, as soon as he gets paid, he'll be done.
Okay. And then Uncle here. Probably do some work too.
All right, you can babysit, you can do something, okay? All right, so I'm gonna adjourn it without a date.
Should we do it closer to when his discharge date comes up?
What would his discharge date be?
So it's sentenced.
So 11,
If we do it in December this year, Judge.
Miss
Yeah.
Adams, could I get, let's do January.
Yeah.
All right, Miss Adams, could I get a January pretrial date?
Okay.
So I'm gonna,
And I'll work something out with him. I'll try to get it paid before December and he can pay me back.
okay. All right, you're very lucky young man to have a grandmother like her.
Judge, I have January 7th at 8:30.
All right, so can I get a notice of hearing from Mr. Gant? So I'm gonna set this out to January 7th at 8:30. So you can babysit, you can help family members, you can do dishes one-handed. I had to do that one time. And there's lots of things you can do to help people out. Just get the money raised or work with your family members. And then as soon as we get the payment, we'll terminate you from probation. So, but I'm gonna set this out to January 7th. I'm gonna enter a plea of not guilty. So you can take care of all this and don't be doing any more of that. The pictures I saw, okay?
Wait, can I, what was in the pictures? I just.
I'll show you.
I'll have you report with it.
Okay.
I know his mom had some, because they had a storm, so she had them cutting.
Yeah,
I'll talk to him.
Okay.
We'll talk about it later. All right, so have a seat right behind you and we'll get you a notice of hearing, Mr. Gant, okay? All right, thank you, Mr. Gant. Thank you, Grandma, Mrs. Gant. All right, back to Mr. Malaro. Bring Mr. Stewart back. Here's your notice. Now, if you get that paid off, you won't have to come back, okay? Yep, you're all set. You can go with Mr. Jones.
All right, have a nice one.
You too. Bye-bye. All right, Mr. Malaro, how do you wish to proceed with Mr. Stewart?
Judge, if we could get a brief adjournment, there's something that I wasn't aware of in talking to Mr. Stewart and the plea offer, and I need to track it down.
Miss Adams, you might have my docket in Mr. Gant's file. Sorry. Thank you. All right, how brief of an adjournment? My next available is in October 8th. You said you were available October 8th?
Yes.
Okay. All right, so we will adjourn this to October 8th at 8:30 in the morning, and you can do the stipend order to adjourn. So Mr. Stewart, October 8th at 8:30, same Zoom number, okay?
Okay, thank you.
Thank
Do
you,
we
Mr.
need to modify his testing conditions? I don't know.
No, he's
what-
been doing,
Okay.
he's been doing really well. Why?
Well, that's what I mean. Do we need to change him so he can test less? Because I'm assuming it costs
We're-
money every time he does
We
this.
reduced it last time, I believe.
Okay.
Right, Mr. Close, from 2 times to 1 times?
Yeah, that's correct, Judge. He was testing 2 times a week and we reduced it to 1 time a week on August 6th.
Judge, I have no objection to the prosecutor's motion to reduce it even further.
I mean, I don't know if random would be less frequent or not, but if it is, we could do regular and random.
That basically is regular random,
Okay.
right, Mr. Close?
It
Once a
is,
week?
Judge. It's random. It's once a week, but it's different days.
Okay.
So, all right, thank you, Mr. Stewart. You have a good day.
You too, thank you.
Bye. All right, Mr. Malaro, I do believe that is all I had with you, correct?
That's what it says for me, Judge.
Thank you.
Have a nice
Mr.
day.
You too. Mr. Nassif, who are you here on?
Good morning, Judge Mayor, Trevor Craig.
Okay, I'll get you next. Mr. McManus' client was here first. All right. So, Andrew Wright. This is in the matter of the people of the state of Michigan versus Andrew Gordon Wright, file number 25-22169FH of Martin McManus, appearing on behalf of Mr. Wright, who's appearing via Zoom. And I need a prosecutor, please. Mr. Bayonetto, Dave McCready, appearing on behalf of the people. So this is the date and time set for a pretrial conference. Mr. McManus, how would you like to proceed?
Thank you very much, Your Honor. At this time, I did have an opportunity to speak with Dave McCready. We have spoken several times trying to resolve this matter. I believe we're getting very close. I know this has been continued for a while. However, from this incident, my client was shot, and then they had to put a bag on him, and he was laid up in the hospital for a while. So we are diligently working trying to resolve this matter. I'm requesting one final pretrial to October 1st.
Yep. How about, okay, October 1's fine. So I will set this over to, make sure I have the right one, Andrew Wright. Yep. October 1 at 8:30 in the morning. So Mr. Wright, your bond conditions are continued at same Zoom number, all right?
Yes, ma'am. Thank you. You have a good day.
You're welcome. And Mr. McManus, if you could do that stip in order to adjourn.
Yes,
You can sign my
I'll
name to
prepare
that.
it and authority Mr. McCready to sign your name.
That's fine.
All right. Thank you very much, Your Honor.
All right, thank you, Mr. McManus. All right, so Trevor Craig is in my waiting room. Is it Nassif or Nassif?
It's Nassif.
Nassif, okay,
Thank you, Judge.
you're welcome. Nobody used to be able to pronounce my name either. And then Alex Anzalone started playing for the Detroit Lions, so now everybody knows. All right, there you go, Mr. Craig. This is in the matter of the people of the state of Michigan versus Trevor Scott Craig, file number 25-22388FH. I have attorney Nader Nassif appearing on behalf of the defendant, and I have Alexander Banetto appearing on behalf of the people. This is the date and time set for arraignment in this matter. Mr. Nassif, have you received a copy of the felony information request for discovery and witness list?
Yes, Your Honor, would acknowledge receipt and waive formal reading and stand mute for purposes of the arraignment.
All right. And when would you like a pretrial on this matter, sir?
Your Honor, we have resolved the case. I did send a signed plea form to Mr. Banetto last night. I'm not sure if it made it to the court file just yet.
Your Honor, I just forwarded that on to your
Oh,
staff,
okay.
so you should have it now. My apologies, I forgot to do that this morning.
Okay. So, Miss Adams, did you send it to Miss Adams or Miss McGrain?
I sent it to Ms. Adams and Ms. Spade.
Okay. Oh, Miss Spade, they always remember you. Okay. There we go. Thank you, Miss Spade.
You're welcome, Judge.
All right, I'm gonna print that off. You're gonna have to bear with me. My allergies are really bad today and I can't breathe. So, all right, thank you. All right, so I have received a plea agreement form that has been signed by all the parties. And it states that the plea as offered is that the defendant would plead guilty to count 2, operating while intoxicated, and an added count 3 of attempted fleeing 4th degree, which is also a 1-year misdemeanor. Well, that's a 1-year operating while intoxicated, 93-day. Count 1, police officer fleeing 4th degree, which is a felony, would be dismissed at the time of sentencing. There is a Killebrew agreement between the prosecutor's office and defense counsel that there would be no upfront jail. And that's the sum total of the agreement as I understand it. Is that correct, Mr. Nassif?
Yes, Your Honor, it is.
Mr. Banetto?
Yes, Your Honor.
All right, so Mr. Craig, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so I'm going to need you to speak up a little bit louder. Can you state your full name for the record?
Trevor Craig.
All right, thank you, Mr. Craig. You've heard the statement of your attorney, the prosecuting attorney, and myself. Is it your intention today to plead to count 2, operating while intoxicated, and count 3, attempted police officer fleeing 4th degree today? Is it your intention to plead guilty to those counts?
Yes, Your Honor.
All right, are you satisfied with your attorney and the advice that he has given you?
Yes, Your Honor.
Do you understand the maximum penalty for these offenses are 93 days in jail and up to 1 year in jail?
Yes, Your Honor.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court other than the Killebrew agreement. Is that correct, Mr. Nassif?
Yes, Your Honor.
And Mr. Banetto?
Yes, Your Honor.
And is that correct as far as you're aware, Mr. Craig?
Yes, Your Honor.
Guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify if you want to testify at your trial. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Craig?
Yes, Your Honor.
All right, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So in your case, there's an agreement between the prosecutor and your attorney that there would be no upfront jail. If you violate bond conditions, if you get in trouble before sentencing, I don't have to honor that. I could give you up to a year in jail. Do you understand that?
Yes, Your Honor.
All right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. So, sir, how do you wish to plead to the charge that on or about July 31 of 2025 in Cambridge Township in the county of Lenawee, that you did commit the offense listed in count 2, operating while intoxicated? Guilty or not guilty?
Guilty.
And how do you plead to the charge listed in count 3, that on that date, time, and venue that you committed the offense of attempted police officer fleeing 4th degree? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than the agreement that was placed on the record?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Nassif?
No, Your Honor.
Mr. Banetto?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be today, your sentence will be, Mr. Craig?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Mr. Craig, on July 31 of 2025, were you in Cambridge Township in the county of Lenawee?
Yes, Your Honor.
And were you driving a motor vehicle on US 12?
Yes, Your Honor.
All right. And would you agree that you had a blood alcohol content higher than 0.08 grams?
Yes, Your Honor.
What had you been drinking?
Several, like Mike's Hard Lemonades from beer.
Okay. And where were you headed?
Back home.
Back home. All right. And at some point you came in contact and you agree you were over the legal limit and shouldn't have been driving.
Yes, Your Honor.
Does anybody know what his actual BAC was?
I believe it was a 0.16. There was a breath test on the road that was a 0.12, I believe. And then ultimately the chemical test result was a 0.16 at the station.
All right. So you were double the limit, right?
Yes, Your Honor.
Okay. And so at some point you came in contact with a officer, Dan Rudd. Let me see, was that, was he Cambridge Township, state, or sheriff? Mr.
Cambridge
Banetto?
Township, Your Honor.
All right. So at some point a police officer came up behind you. Is that correct?
Yes, Your Honor.
And did he hit his lights so you knew he was a police officer?
Not at the time, but I knew he was behind me. The lights weren't
Okay.
on
Did he,
for a
at
while.
some point, did he turn his lights on?
At some point, I never saw them, but yes, Your Honor. At some point, they were on.
Okay. Did he try to pull you over?
Your Honor, if I may interject briefly.
Yeah.
Mr. Craig, were you trying to avoid being pulled over by the officer on the road?
Yeah, I was trying to avoid being pulled over.
Okay, so you knew he was there, and you knew he was likely after you to pull you over, but you attempted to evade his to evade him, correct?
Yeah, I knew he was likely coming after me. I didn't know if if it was initiated. That's correct. Yeah.
Okay. All right, I believe that would satisfy it.
Are you satisfied, Mr. Bannell?
The only thing I would ask to clarify is, Mr. Craig, he did in fact at some point turn his lights on to try and effectuate the stop, correct?
No, we were at my house when he turned them on. And that's his body cam. Like he says that in his own body cam when I rewatched it back as well.
What time of day was this, Mr. Craig?
About 9 p.m. I believe, so nighttime. Yeah.
Okay, and it's still light out at 9 p.m. Is that correct?
That's correct.
So he was in a clearly marked police vehicle.
Yes, Your Honor.
Okay, and you took off from him because you didn't want him to pull you over and he followed you.
Yes, Your Honor.
And you would agree that you went over the speed limit? Or did you just drive to your house and not pull over?
You just drove to my house. Yeah.
Okay. All right.
I'd be
Mr.
satisfied
Bannell?
with that, Your Honor.
Okay.
Defendant satisfied, Your Honor. Thank you.
Has the court complied with MCR 6.302 B, C, and D? Mr. Nessie
Yes, Your Honor.
and Mr. Bannetto?
It has, Your Honor.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He has competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for pre-sentence investigation. So, Mr. Craig, because these are misdemeanors, you're going to have to get a PSI done by district court probation. And so,
Your Honor, if I just briefly.
Yeah.
Sorry. I just wanted to know, Mr. Craig now lives in California. He's originally from California, and the time he was living in Lenawee County was during this period with his fiance and fiance's family. That relationship was ultimately ended, so now he is back in California. So I just wanted to make sure the court was aware and see if there's any, make sure there aren't any issues, if he's able to meet with them virtually or things of that nature. So I know that
he
might
should be able to do that. So, but I'm going to chat you the phone number of the probation officer to the two of you.
Okay.
So give me just a minute. And I'm gonna chat the name. It's Mike McCarron. And I may misspell his last name. And his phone number, I'm chatting now. District court is on this.
4683, Judge. 4683. 264. 4683.
Okay, all right. I'm sending it to you now. And you can share that with your client.
I will, Your Honor. Thank you.
All right, so Mr. Craig, your attorney or you will reach out to Mr. McCarron and explain to him that you live in California. And then Mr. McCarron, I'm fine with him doing the PSI virtually. I don't have a problem with that. And so, Mr. Craig, I assume you want to Zoom for sentencing, right?
That'd be great, Your Honor.
Okay, so we will set sentencing via Zoom and October 17, are you available, counsel, on that day?
Yes, Your Honor.
So we'll set sentencing for October 17 at 8:15 in the morning. I don't know, time change, you might have to get up early or late, I'm not sure, Mr. Craig, but we'll be all right. And then, let's see. All right. And write that date down. And that'll be via Zoom. So what'll happen at this point is you and your attorney are going to reach out to Mr. McCarron. Mr. McCarron will interview via Zoom or phone, however he does it. He'll prepare a pre-sentence report. We'll provide that to your attorney. Your attorney will review that with you before sentencing. Be truthful with them about your background, the events that occurred, and we will see you back on that day. All right?
Thank you, Your Honor.
All right. Thanks, counsel. You're all
All right,
set. Thank you.
Have a great day. Fingers straighten out. All right, thank you.
All right. It's Harry Potter's birthday. Maybe we should have stayed with butterbeer and not what he was drinking. All right. So I got Mr. Murphy. I got Mr. Fry. And Mr. Murphy, let me see.
I'm sorry. I'm so sorry. Can somebody hear
Ms.
me?
Gibson, good morning.
I'm sorry.
What are you sorry for?
I didn't know if you called my name.
Nope, you're fine. Let me see. Mr. Fry, are you with us? Okay.
Yes.
This is in the matter of the people of the state of Michigan versus Sierra Gibson, file number 25-22225 FH. I have Douglas Hartung appearing on behalf of the people, and I have Brian Fry appearing on behalf of Miss Gibson. This is the date time set for a pretrial. I do have a letter from Darren Coast dated September 2nd, stating Miss Gibson is doing a little better with her 1 time a week drug testing. She has made her last 3 tests and is staying away from any illegal controlled substances. So this is date time set for pretrial. So Mr. Fry, how do you want to proceed today?
Your Honor, we have been waiting for Miss Gibson to be screened for recovery court. I think she was last time, and I don't think she was eligible. Is my recollection. But we need a little bit more time to have some discussions with the prosecutor and see if we can come to a resolution or not, and then decide whether we're going to set it for trial. So we'd ask for an adjournment.
October 8th, Mr. Fry.
October 8th. Yep, that's fine.
All right, so we will set this over to October 8th at 8:30 in the morning. Mr. Fry, can you do the step in order to adjourn? And Miss Gibson, just keep testing with Mr. Coast, okay?
Yes, ma'am.
And Judge, I'm
Anything
sorry, I
else?
missed it. What's the next date?
October 8th at 8:30 in the morning.
Thank you.
All right, Mr. Hartung, anything else?
No, thank you, Your Honor.
Mr. Hartung, could I sign your name with permission for that adjournment?
Absolutely. And if on another matter, Brian, give me a call tomorrow if you can.
Okay.
Thanks.
Yep. Thanks.
All right, thank you. Mr. Dillard, I haven't forgot about you. Miss Underwood's still next door. Judge will save her. All right, so I don't have Mr. Noe yet, Mr. Hartung. And his client's probably with him in his office. So.
His client's in jail, Your Honor, just so you know.
Say it again.
His client is in jail.
Oh.
He's in our jail.
Okay. Yeah, he is jail. All right, Mr. Murphy. Oh, and there's Mr. Noe. So let me call the jail.
Little County Jail.
Hi, this is Judge Anselone. Can I have Michael Isaac, please?
Yeah, absolutely.
Thank you.
Thank you.
All right, Mr. Murphy. Okay, so Mr. Lake, you have Mr. Murphy, right? You want to come up here? All right, just stand at the podium for me. Okay, this is in the matter of the people of the state of Michigan versus Christopher David Lake, file number 25-22333 FH. I have Phoebe McClure appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Lake. Mr. Coast, do you have information on Mr. Lake? your video's on, so.
I'm sorry, Judge, you said, Mr. Lape?
Lape, L-A-P-E.
Yes, Judge, he is testing. He's tested with me. He's also been testing in, Hillsdale, and, all tests have been negative. He's done very well.
Very good, thank you. All right, Mr. Murphy, how would you like to proceed with Mr. Lape today?
Your Honor, the offer at this time, as I understand it from the prosecution, would be for Mr. Lape to plead to possession of methamphetamine, dismissal of the remaining count with an agreement for him to give up the weapon involved here, the knife, I believe that was in the vehicle, with no habitual offender status and agreement for no jail. I believe at this point, Mr. Lape is currently in Hillsville County Recovery Court. I just wanted to make sure that was, if I was correct on that, but I hadn't been able to speak to Mr. Lape about that offer. I didn't know if he wanted to talk to me in a breakout, if he wanted to proceed, or if he wanted me to ask to adjourn for further discussions about it, but.
So Mr. Lape, the plea offer in this case is to plead to 1 count of possession of methamphetamine. Obviously, you're in recovery court in Hillsdale.
Yes, ma'am.
So, there's no upfront jail, so it wouldn't, yes, Ms. McClure.
Just to add in, I have spoken with Dave Face, who's been in pretty constant, because he's supervising Mr. Lape on parole. He's been in pretty constant contact with the Hillsdale Recovery Court program, and Mr. Lape's in that through the family court. It was a family court agreement that he go through that program. And Mr. Face has already checked that this plea, one would not, he's already pled guilty to his parole violation for this methamphetamine, as far as I know. I think that's what he reported. But that this plea would not jeopardize his status in that recovery court program. So that's what's been represented to me. Obviously, I've not spoken to them directly, but that's what Mr. Face has represented to me.
Mr. Murphy?
Yes, I just, obviously I was wondering if Mr. Lape wanted to talk to me in a breakout, or if he understands and wants to proceed, or if he wants.
So Mr. Lape, yeah.
Proceed.
You want to proceed?
Yes.
So you understand the plea offer, and that from the information we have from MDOC, it won't interfere with your program there.
Yes, ma'am.
Okay. And you understand though, if you screw up or something, you could go to jail here.
Yes, ma'am.
Okay. So do you want a chance to talk to Mr. Murphy?
No, I'm okay.
Okay. So, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, and I got an advice of rights for you because I always forget about that. So, but luckily Doug does not. So I'm going to go over those rights with you now, and we're going to have you sign it, and you can read along with me and take a minute to read it. Mr. Noe, do you need a breakout room with your client?
I do need one, Judge, please. Thank you.
So, the gentleman in yellow, what's your name?
Isaac, Michael Isaac.
Yeah, I just wanted to make sure I put the right person in there. All right, so I'm going to put you in a breakout room with your attorney. All right, go ahead and join that breakout room. Okay. All right, so Mr. Lape, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to count 1, controlled substance possession of methamphetamine?
Yes, ma'am.
Now understand that carries a maximum penalty of up to 10 years in prison and or a $15,000 fine. But the Killebrew agreement between the prosecutor and your attorney is that there would be no upfront jail.
Yes, ma'am.
All right, and do you understand that count 2, count 3, as well as your habitual offender 4th offense notice would be dismissed at the time of sentencing?
Yes, ma'am.
Okay. And are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, ma'am.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court other than no upfront jail. Is that correct, Ms. McClure?
That's correct. Other
Mr.
than
Burke?
forfeiting the knife.
Oh, yeah. You understand you got to forfeit this double-edged, non-folding knife with wooden handle?
Yes, ma'am.
Okay. All right. And is that correct, Mr. Murphy?
That's correct, Your Honor.
And correct as far as you know, Mr. Lee?
Yes, ma'am.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. In your case, you have an agreement that would be no upfront jail. Before this change in the court rules, even if you violated your bond conditions, that agreement would stand, and if I didn't honor it, you could withdraw your plea. But now, if you violate your terms of bond, you get in trouble with your Hillsdale court, or you commit a new crime, I can sentence you to prison. Do you understand that?
Yes, ma'am.
Okay. And do you have any questions about the rights that I've given to you?
No, ma'am.
All right. How do you wish to plead to the charge that on or about February 10 of 2025 in Rollin Township in the county of Lenawee, that you did commit the offense listed in count 1, controlled substance possession of methamphetamine? Thank you. Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
And the record should reflect I received back a signed copy of the advice of rights. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. McClure?
None, Your Honor.
Mr. Murphy?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be outside of the plea agreement?
No, ma'am.
All right. Is it your own choice to plead guilty?
Yes, ma'am.
All right. So Mr. Late, on February 10 of 2025, we're in Rollin Township in the county of Lenawee?
Yes, ma'am.
All right. And at that time, did you have in your possession methamphetamine?
Yes, ma'am.
Did you have any legal right to possess it?
No, ma'am.
All right. Did you know it was methamphetamine?
Yes, ma'am.
All right. Are you satisfied, Ms. McClure?
Satisfied, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. McClure?
It has.
Mr. Murphy?
It has, Your Honor. Thank you.
All right. Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Murphy, are you available October 17?
Yes, Your Honor.
So I'm gonna set this for sentencing on October 17 at 8:15 in the morning. Ms. Adams, could I get a notice of hearing from Mr. Lape? Now, Mr. Lape, are you living in Hillsdale now?
No,
You're still on 223?
no, ma'am.
Okay, so I'm gonna send a Post-it note down to you, and I'm gonna ask you to update your address, because I don't have a newer, the only address I have for you is probably not valid anymore. So I just want to update it in my system, okay?
Yes, ma'am.
So if you can just write your address down. And then I'll give that to Ms. Adams to update our system.
No.
Great. So, Mr. Late, thank you. Okay, so Mr. Late, when we're done here, I'm gonna send you across the hall to the probation department. They're gonna give you some instructions, all right?
Yes, ma'am.
When you meet with them, be truthful about your background, the events that occurred, make sure you're truthful with them about what's going on in your recovery court program in Hillsdale. It's a great program. I'm so glad that you're taking advantage of it. Do you want to appear for sentencing in person or via Zoom?
In person.
In person? All right, so I will mark down in person. All right, so we will see you back on October 17 at 8:15 in the morning. We're gonna get you a notice, so have a seat right there and then just go right across the hall. All right, thank you. Or
Mr. Lape, if you could
Stevenson.
contact my office to schedule an appointment, come talk to me in the next few weeks, please.
Yes,
All right, Your Honor.
And then when we get the PSI, Mr. Murphy will reach out to you about a week before sentencing to review that with you. If you don't hear from him, make sure you reach out to him, okay? All right.
Thank you.
All right, Mr. Noe. Thank you, Ms. Adams. All right, Matt, you have Erica Wright.
Yes, Your Honor.
Right, in the matter of the people of the state of Michigan versus Erica Lynn Wright, file number 25-22217FH. I have Matthew Murphy. Oh, I have Jimmy McClure appearing on behalf of the people. Matthew Murphy appearing on behalf of Miss Wright. Miss Wright is neither in my waiting room, the hallway, or the courtroom. Mr. Coast provided an update that she's only tested once since her last court date. She has been extremely sick. She was supposed to be here in person, but she is not here. Mr. Murphy, I know that she had some major issues health-wise and surgery, but have you heard from her?
Unfortunately, I have not, Your Honor. I tried to reach her and haven't. The last time I spoke with her, I guess, would be the last court date.
All right, so I am going to issue a bench warrant for her arrest for failure to appear. She has a prior failure to appear on May 21, so I'm gonna set bond in the amount of 10,000 cash. Mr. Murphy, if you reach her, obviously we don't sign these for 48 hours. I don't know if Mr. Coast, do you have any recent updates with her?
Judge, I did speak with her the other day, and I did tell her to be here in person. She's not in the hospital. And when I did speak with her on September 2nd, she did indicate to me that she was feeling better. So I don't know why she's not here.
All right, so Mr. Murphy, obviously, if you're able to reach her, let us know. And I think, Mr. Murphy, that's all I have with you.
Yes, that's all that I had down, Your Honor. I do apologize for Ms. Wright. Obviously, if I get in contact with her, I'll have her appear. Thank you.
Well, don't apologize, Mr. Murphy, you were here. All right.
Yeah.
Okay. Mr. Noe, let me get the client's file. All right, this is Mr. Hartung on this one. Right? No, I'm just talking to myself, Joanne. Okay. That's how I get them to turn their video on.
Okay.
All right, this is in the matter of the people of the state of Michigan versus Michael Anthony Isaac. We have two files, 25-22348 FC and 25-22349 FH. I have Douglas Hartung appearing on behalf of the people, and I have Charles Noe appearing on behalf of Mr. Isaac. Are you a special appointment or retained?
I've just been retained, Judge.
Okay, so let me mark that. All right, so this is a date and time set for a pretrial. Mr. Noe, how would you like to proceed?
Thank you, Judge. In this matter, I have just been retained less than a week ago in this matter. And I just gotten some of the discovery with the assistance of the Public Defender's Office. There's still a lot more for me to go through. There's two cases here, two seemingly maybe unrelated cases. So it's a lot to go through. I discussed that with my client, met with him over the weekend, went over a lot of things with him, had a productive meeting with him, and ultimately was able to get some information from him to aid his defense. What we'd like to do is set this matter for another pretrial, 30 to 60 days out. I think I heard some October dates earlier during the docket. We can do that. And then we'd also like to address bond at that time, at this hearing as well.
You know, Mr. Noe, I'm so sorry. Like for some reason we hear you and then it kind of gets muffled. So
Sure,
you wanted 60 days out?
32, 60. I think I heard some like mid to late October dates. Judge,
How about October 15?
Just one moment, please. That works.
Okay, so I'll set a pretrial conference for October 15 at 8:30 in the morning. And you can do the step in order to adjourn.
Sure. May I sign that with your permission, Mr. Hartung?
Yeah, absolutely.
And were you addressing bond?
I would like, yes, thank you. May I proceed?
Yes.
Your Honor, my client is currently, I believe, on a little over $500,000 cash or surety bond in this matter. Judge, my client would be asking for a reduction of bond, if not a PR bond, with several conditions. I understand my client does have a lengthy history. I'm sure Mr. Hartung will address that. I certainly would if I were him. But ultimately, my client, it's kind of an interesting argument. I enjoy making this argument in front of the court.
Are you picking them up? So, Mr. Noe, when you lean back, we lose you.
Okay, is that better?
Yes.
Okay, all right. My client does acknowledge his lengthy history with the court system, but ultimately my client, I enjoy making this argument, has no failed to appears ever. He's always shown up for court. He's always been there at court. He's always been present. My client acknowledge would be agreeable and understandable if the court were to order a tether or to order some sort of work restriction on him, or he could be under some sort of time restriction where he can only be out during work hours. In addition to that, if any sort of drug or alcohol test in the court would require him, certainly understandable. My client is not necessarily a threat to society. I don't acknowledge at this time he's a threat to either the alleged complaining witnesses in this matter. I assume there's already a condition for no contact that would obviously remain in place, but a tether could be in place to make sure that my client doesn't contact or be close to any of the people in this matter. One of the complaining witnesses himself is currently in Illinois County Jail, and the other complaining witness, I don't know where she is, and I don't need to know. Neither does my client. So ultimately, we would be asking for reduction of bond. My client will appear for court. Any threat to society can be addressed through conditions, which I think would be very appropriate. and my client would certainly be understandable with that. I understand this request. The court will take it seriously and consider it appropriately. And I think that my client can show that he is able to appear for court. Again, no history of failure to appears and no history of any sort of violation of conditions or anything like that, no contact, something like that. I mean, I think that covers the requirements of the bond setting regarding the failure to ensure his appearance and also protection of society. And I think that my client could very easily do that. And I think would do that. If he violated any of those, then he'd be right back where he is. And I'd have a tough time arguing otherwise. So that's what we'd be looking to do today, Judge. Thank you.
All right, thank you. Mr. Hartung.
Your Honor, the defendant, I'm going to be a little longer than usual, but the defendant has a criminal history in California that is, when we printed it out, was approximately 35 pages long. And nothing in Michigan.
Escape from custody.
Nothing in Michigan. The habitual offender notice lists, I think, 9 or 10 prior felony convictions. Looking through that 35-page history also showed numerous violations of probation. He also had some obstruction charges that were involved in California. I'm not aware of any failure to appears. There may be some out there, but I'm not aware of them as of this moment. The cases that we have here today, the file that ends in the file that ends in
4-8.
No, it's the other one. 4-9. Involved a shootout between himself and another defendant who's already pled guilty, Donald Hawkins, in the city of Tecumseh, late in the morning, near the waterworks area in that town. So the idea that he's not a danger to society may be, kind of a pipe dream. But those two engaged in a shootout with each other. Luckily, no one was struck, killing them. But Mr. Isaac, this defendant, was struck in the face and in the ear area during that gunfight. The other charge is a very serious CSE charge, wherein his niece flew in to meet him for the first time. And on the very, very first night that they spent in his home, he sexually assaulted her. That's the allegations in that case. We have, she was 16 years old at that time. He denied doing it to the police. The sane nurse that took care of the victim on that evening took the appropriate samples. Those samples have been sent to the laboratory. We got the first part of the testing results back on that yesterday. I shared those results with Mr. Noe by messaging and by phone, I think yesterday afternoon. That indicated that the sane examination of the victim in that case established that there was male DNA in her at the time of the examination. We do not have the numerical breakdown that we would normally get as to the likelihood that it is this particular defendant, but we expect those results to be coming forthwith. And as soon as I get those, whether they establish that this defendant is the individual involved or another individual involved, I will immediately contact Mr. Noe and let him know of those results. So at this time, we see absolutely no reason whatsoever to reduce the bond. One more thing. On the night of that shootout, and this was just a few days after the criminal sexual assault incident, Mr. Isaac told the police that he was going to that location that night to kill himself. And he had in fact fashioned a noose to take with himself to that location with the idea of hanging himself. So on top of all the other charges that we have here, we have a concern for his welfare as well. So absolutely no way are we in a position to agree to any reduction of bond at this point in time.
Your Honor, may I respond very briefly to a couple of Mr. Hartung's assertions? So, very briefly. Your Honor, while I certainly appreciate Mr. Hartung invoking the seriousness of the shooting offense, it's kind of somewhat dubious to assume that it is so serious when the co-defendant's case has already been pled with a Cobb's to 1 year in jail. So while there may be some sort of, while Mr. Hartung may feel this is a very serious incident, a very dangerous incident, how dangerous and serious can it really be if they've already reduced the co-defendant's case, where my clients would have got shot, to a year in jail? So while I certainly understand that case, that it's serious, of course it's gunplay, it's always going to be serious. But I think let's look at it in the lens of which this particular incident is being viewed at. Again, this is not me, this is the people's perspective, a year in jail. So ultimately, I think while I appreciate that argument, I think you have to look at it in the context of this particular incident. Regarding my client's history, he has no history of any sort of criminal sexual conduct offense, and has vehemently denied the allegations that he engaged in criminal sexual conduct. My client stands before the court not guilty or of either of these incidents. And any sort of, if the court were concerned about his physical safety to himself, the court can order him to go to CMH, can order him to go to some sort of therapy as part of his release conditions. He'll do that. I for sure, more than anybody, and on that I completely join Mr. Hartung. I don't want my client or anybody to do something silly and harm themselves. I think that if my client can address that properly and be ordered to do that through a CMH or something like that, I have no objection to that. That makes a lot of sense. I certainly want him alive and well. I don't want to do something silly and irrevocable. I would join Mr. Hartung in that concern, but I don't think incarceration is the proper way to address that particular concern.
All right, thank you. So in file number 25-22348 FC, Mr. Isaac is charged with 1 count of criminal sexual conduct, 1st degree, count 2, furnishing alcohol to a minor, count 3, criminal sexual conduct, 3rd degree. And then he has a habitual offender 4th offense notice, but there's about 9 of them listed, one of which is actually a felony escape from custody jail with force. So that to me denotes some portent of a flight risk. And then on the other file, 25-22349, he has multiple firearm charges. And with his prior felony convictions, he's not allowed to possess a firearm. So, and also I'm not going to reiterate Mr. Hartung's statements, but the court does believe that he's a threat to himself, others, and society, as well as potentially a flight risk. So I'm going to deny your request for bond. So we will see you back on October 15th at 8:30 in the morning. Thank you.
Thank you, Your Honor.
You're all set, Mr. Isaac.
Your Honor, if I can say something real quick, the escape charge, Your Honor, what had happened, it was not like
Mr. Isaac, it doesn't matter. I'm all set. Thank you.
I'll get a chance to talk to you about whatever you want to talk to the judge about. I'd rather it come from me. I'll come see you, and we'll discuss whatever you're going to say. We'll take care of it at the next hearing. I promise.
Thank you.
Thank you. I'm ready on my next matter as well, Judge.
Your next one is Becky Williams, but she's Rebecca Williams. She's
That's
just
right.
listed as Becky. Hold on 1 second. Okay. Hold on 1 second. Okay, Miss Williams, can you hear me?
Yes, I can.
Okay, excellent. This is in the matter of the people of the state of Michigan versus Rebecca Sue Williams, file number 23-21606FH. I have, I don't know who's been practicing longer. Aymee McClure appearing on behalf of the people, and Charles Noe on behalf of Miss Williams. Oh, Mr. Noe is senior attorney here, so I should have called his name first. So, Mr. Noe, how would you like to proceed with Miss Williams today?
I don't know if I like being called senior attorney, Judge. I don't know if I like that or not, but I guess.
It happens overnight. You go from a newbie to senior attorney.
I saw that at my CDM conference. It was enlightening. But Judge, and we had a bench conference on this matter last week. We determined that we are setting this matter for a pre-trial December 17th at 8:30, and a jury trial set for September 23rd through 27th. I believe the court was going to issue a scheduling order, and that is, I believe that's what we're looking to do today.
I have a scheduling order showing. Go ahead, Ms. McClure.
At bench conference, we adjourned that September pre-trial or that September trial and got new trial dates, which is why we wanted to have the pre-trial today. So our new final pre-trial date is December 8th, and our new jury trial dates are February 23rd, set for 5 days. February 23rd,
So,
2020.
Hold on. I have the final pre-trial conference for December 17th. On the scheduling order I did, I don't know why, but it says December 17th.
We had talked about doing it December 8th, but if it's the 17th, that's fine.
Mr. Noe?
Yeah, December 8th is a Monday. I guess we can do it on a Monday during Monday.
No, we can't do it on a Monday. I have December 17th. So,
yeah.
All right. So I have a jury trial scheduled for February 23rd at 8:30 in the morning. And we said that's for 1 week, correct?
That's right.
Correct.
Okay, and then final pretrial conference is December 17 at 8:30 in the morning. Voir dire questions and jury instructions are due February 6th of 25. Expect the parties will meet, go through them together and submit to the court. One copy, if there's any that we are disagreeing on, we will meet in advance of the trial. And motion and limiting deadline is February 20th of 2025. If you file any motions, that would be that Wednesday, February 20th.
And then two things for the people, Judge. One, the people are requesting that the court order Mr. Noe to turn over all of his discoverable materials. As he's indicated, he's received quite a bit from Sterling Estates via subpoena, and also intends to hire an expert that we've not gotten anything from yet. So I would just ask the court to order that. And then I would also ask, because of the jury trial delay, which was set for this month and is now being moved to February of 2026, I would ask Ms. Williams to waive her right to speedy trial on the record.
All right. Ms. Williams, you understand you have a right to a speedy trial, but because of the nature of everything, your attorney is requesting an adjournment. Do you have any objection to the trial being adjourned to February of next year?
No, I do not.
Okay, excellent. And Mr. Noe, with regard to the request for discovery?
Judge, in terms of the request for discovery, as of right now, I would object to that and require the people to file a motion on that matter. Under MCR 2.302, that's work product, and that's documents that are in anticipation of litigation and records that I have. In terms of on the Michigan court rules, discovery is limited to matters that are not proportional or not relevant at this time. They're not being offered at any time. And in addition to this, forcing disclosure of a defense obtained records would infringe on my client's Fifth and Sixth Amendment rights to effective assistance and prepare defense without state intrusion. Brady versus Maryland flows one way. It does not flow the other way. So if the opposing party wants records, they can issue their own subpoenas. And I think that each side must independently pursue discovery, especially in something like this. So I think that I would object to that and object to this being made orally at this time. But if Ms. McClure wants to make that motion, present that, I certainly will obviously have to respond to that and deal with that. But as of right now, I would ask to deny summary requests right now.
Your Honor, maybe it was misunderstood my request, but my request is simply limited to what he intends to present through his expert witness, as he does have the obligation to provide me a summary of what his expert witness is intending to testify to, as well as any materials intending to be used by them. I do believe, though, anything he's subpoenaed is discoverable, but if I need to file a motion on that, I will. But really, at the heart of this, it's just we needed something from his expert.
Oh, and I completely agree. In terms of the expert testimony, that will absolutely have to be disclosed under the court rules. That's absolutely, that's a different story. 100%. If I intend to have an expert witness, I'm not gonna have a trial by surprise. The reports, information that was used to complete those reports, that all must be provided timely. I completely agree.
Okay, so obviously, Ms. McClure, you probably should file that formal request for discovery, as we all do.
I have filed that.
And then Mr. Noe, you can file a response if you object to any of it, but it sounds like with regard to the expert witness, you're planning to provide that to her, so.
I have to.
All right. Okay, thank you, everybody. Have a good day. And Mr. Noe, I have the scheduling order, so we'll get that out. Thank you.
Well, thank you.
Yeah.
Bye. And so, let's see. Amanda Underwood's next door still. She's still over there right now. So Miss Underwood is finishing up, it looks like, in front of Judge Olsaver. So Mr. Dillard, it should just be a few more minutes.
Hey, I got a question, Enzo.
Yes, Mr. Dillard.
I had court yesterday. I didn't get zoomed in court yesterday.
You had court with me?
No, for my OUIs. Before I came back to prison, you told me I couldn't even come to court for my violation until I resolved my other cases.
So you were supposed to have court in district court yesterday?
Yes.
I wouldn't know, Mr. Dillard, because that's a completely different court. So, we'll look it up to see if you had something scheduled in district court. I think Ms. Spade is looking that up now.
It was for an OUI and driving with no license.
All right, hold on, we'll find out. So,
We did. We're scheduled before Judge Schaefer at 8:30. They don't have any notes of what they did.
They didn't set up Zoom for him?
No. It says notice to, no, defendant must appear in person, it says, on their notes.
Yeah, because I paid a bond and then I came back to.
Yeah, hold on, Mr. Dillard, did they issue?
Well. WI with occupant under 16. And there's another one.
Go to the center. Hey, this is Judge Anzalone. Do you have Brianna Spiegel down there?
I do.
Can I see her?
Yeah, I'm gonna send her upstairs to middle for you, so they'll get her set up, okay?
Awesome, thank you.
Yeah.
Bye.
That's the only one I see, Judge, but it was scheduled for a pretrial.
Yeah, I just want to plead guilty, Enzo. So
I know, so Mr. Dillard, that's district court. Does he have an attorney on that one? All right, so we're not gonna talk for a minute because Miss Spade's gonna look something up. Who's the attorney?
It doesn't, they don't put down. They just put a public defender, that's all they put. They don't specify who it was.
Okay. All right, so Mr. Dillard, hold on a minute and we're gonna try to, I don't know, you did have court yesterday in district court, but they had you listed in person. So that would have been difficult on your part to do, right?
yeah,
So,
I thought I had Underwood for my attorney as well, though, because she seen me in both cases.
maybe, but we're waiting for her. So hold on, I'll be right back.
That's my law.
All right, I will be right back, Mr. Dillard. Hold on. All right, Miss Spiegel, hold on a minute. This is in the matter of Brianna Lynn Spiegel, file number 22-20816FH. 24-21737FH and 24-21738FH. So Ms. Spiegel, we are here today on a request and warrant for probation violation. On each file, it states that it is alleged that you have violated the terms of your probation, that you were ordered not to use any illegal controlled substances. And on September 2nd of 2025, you admitted to use of methamphetamine on August 30th. And on July 8th of 22, you were ordered to complete the adult drug treatment court program. And you failed to do so, and that you have not obtained residential treatment as instructed by the field agent on August 26th of 25. And let me see, where is?
Told me this like a week ago.
Hold on, I can't hear you. That room has really bad audio, so hold on.
Hi, Judge.
Hey, can you zoom in with Ms. Spiegel?
Yeah, I'm on with Old Saber, but I can run over there if
Okay.
you're doing her right now.
I am right now.
Okay.
All right, thank you.
Bye.
So Ms. Spiegel, on 22-20816FH, you're on probation for possession of cocaine less than 25 grams, which carries a maximum penalty of up to 4 years in prison if you plead guilty or found guilty. On file number 24-21737FH, you're on probation for possession of cocaine less than 25 grams, which also carries a 4-year penalty. And then on file number 24-21738FH, you are on probation for controlled substance possession of analogs, which carries a maximum penalty of up to 2 years in prison if you were to plead guilty or be found guilty. So Ms. Spiegel, you do have the right to have an attorney represent you here today on this and then any subsequent hearings. Would you like an attorney appointed to represent you?
Is it new charges? Or is it
No,
just
it's a violation. Just a violation of probation.
Yeah, yeah.
Yeah, you want an attorney?
I did,
Okay.
I did the charge. I did it.
Okay, hold on, Ms. Spiegel. Hold on 1 second, all right? All right.
Huh? Not cute. No.
Okay.
No.
So Ms. Spiegel, you understand that as part of the recovery court program, what would happen at this point is that if you were to plead, you would be sentenced to rehab. So you wouldn't get released and you would go to a rehab program. Do you understand that? Inpatient?
I did all that stuff yesterday, so I'm waiting on.
No,
a
I'm
call.
just asking you, do you understand, like, because you're wavering on an attorney, if you were to plead, you're looking at remaining in jail until we can get you a bed at an inpatient program and continuation of recovery court.
Oh, can I get a lawyer then?
Yes, yeah. So we will, you're just gonna have to wait a minute till Miss Underwood gets here, okay? So we're all set, Ms. Tessman.
Okay, just call me back.
I will.
If you need me.
All right, so Ms. Spiegel, I'm gonna, we're waiting for Miss Underwood and then we'll take care of Mr. Dillard, then you. So I'm gonna rename your page and I will put you in the waiting room. And then when we take care of Mr. Dillard, when Miss Underwood gets back, we'll bring you back, all right?
Okay.
Okay, I'm gonna put you in the waiting room.
Judge, will you need me on Mr. Dillard?
He is a violation of probation. So the only thing I have left on my, other than those would be, I have a conference, a bench conference at 10:30 on Hawkins, but I think that's Mr. Hartung, right?
Mr. McCready, I believe.
Okay, all right, so yeah, I'm good with you then. Thank you.
Okay, we'll call if anything pops up and you need me. I'm around.
Okay, thank you.
Yep, bye.
Bye. Joanne, who's in Judge Shaver's office? Is that?
Okay, that's, I would check with Laura Schwartz, 4651. It's either Laura or Krista. That's either Laura or Krista.
Laura, this is Anne Ranswell. So I have a question for you. I'm on the record and I have a William Dillard. And he's in, Mr. Dillard, what facility are you in?
I'm in RGC right now in Jackson.
Oh, okay. So William Dillard is in MDOC. And he had a pretrial yesterday on a couple of misdemeanors. Okay, because he knew he had court yesterday. And okay, do you know how far that's going to set out?
Can I just plead guilty?
Mr. Dillard, hold on just a minute. Well, I can't do anything with mine until he takes care of that. Yeah, because I have a bot too. He wants to plead in front of one judge. And what time would that be? September 16th at 8:30. Thank you. Bye. All right. So Mr. Dillard, I can't take your plea on a misdemeanor because I'm not a district court judge. I'm circuit court. Okay. So I called district court and your public defender made sure they were aware you were in prison. So they're setting your pretrial via Zoom on September 16 at, I think she said 8:30 in the morning. So what I'm going to do on mine is set mine for September 17. So that way we can take care of it that week, right? So when your attorney gets here, we'll put those dates on, okay?
Hey, so my attorney can't just plea out for me, like, man, this is what we went through the last time, and so I'm
because you know the Constitution. Hey, Mr. Dillard,
Oh,
I know you're
God.
frustrated. I get it.
I'm in prison waiting for this shit to be over with. Like, I'm sitting
I know,
here
Mr.
waiting
Dillard.
for this. This isn't my
Mr.
fault.
Dillard,
Like, I'm ready
hold
to get
on.
this shit going.
Mr. Dillard,
God,
I'm not a district court judge, and I'm sorry.
So
I
why is it-
recognize. Why are you talking over me? I'm trying to explain something to you. I know that you're frustrated, but it's, you have constitutional rights and due process and all this stuff. So in 2 weeks, you're going to come back for your district court case. And then the next day, well, actually, Miss Adams, what does September 16th look like late morning for us? Could we do like,
You have a guardianship hearing, 1 hour hearing at 8, and then 9 o'clock motions.
okay. So how long does Judge Shaler take to do pre-trials? Where you guys left?
She doesn't get here till like 30. It could be hours.
Okay. Okay, so we're gonna get it all in 1 week where we try to take care of everything for you, Mr. Dillard. So, I can only do what I can do, and I'm not a district court judge, so I can't take care of that, okay?
I guess.
I can only do
what
mine.
What else can I say? But okay.
I know. If I could take your file from district court today, I would, but I'm not allowed to do
I'm
that,
saying,
Mr.
so
Dillard.
why didn't I have court yesterday? Like they know I'm in fucking prison. They the ones that's sending me back. Like everybody knows what's going on but them. How?
No, district court doesn't know what circuit court does. It's two different courts. So, we don't use the
So
same
when am I
system.
gonna
We
talk?
don't.
when am I gonna talk to this lady or whoever is this attorney? Cause I still haven't even fucking talked to her. Like, I don't even know what's going on with
Okay,
you. When is she coming?
Mr. Dillard, I'll tell you what, stop dropping F-bombs, because we're in court.
Well, I just see you on the 16th. I'm ready to go.
No. Your attorney is gonna be here in a minute, but your attorney goes to Judge Olsaver first and then to my courtroom. So I'm watching right now. She is in front of Judge Olsaver right now. And I'm watching. She's in front of Judge Olsaver right now. So it will just be a few minutes. And then, like I said, we're going to bring you back on everything during the same week, okay?
Hey, so how much time am I looking at with you?
With me? You got an attorney. I'm not really supposed to. Okay, hold on. Hold on.
Like, I request a new attorney. I sat in the county 2 weeks and I didn't know nothing. Like, I don't think she's good enough to represent me.
You know what?
I don't know.
Miss Underwood does a great job, but Mr. Dillard, I mean, it's not really her so much as just the court system, and you know how bogged down it can get. So just bear with us for a minute, and Miss Underwood will be here, and then she will talk to you. And I just sent her a chat. Oh, look, she's reading my chat. Oh, she kind of left. And she smiled. Now she's sending me a message back. Let's see what we got. All right. Oh.
She that busy, she texting, huh?
No, she is sitting in front of Judge Olsaver, and I sent her a message saying, but I need you. And she's got a client. I'm watching her YouTube, or the judge's YouTube right now.
Don't she got a partner or something? Ain't they a law firm? Like,
So they are like a law firm, yep. So there are multiple public defenders in the public defender's office. Miss Underwood handles the violation of probations and contempt of courts, as well as a lot of the MDOC cases, and she's coming in. Look, she just logged out of Judge Olsaver, so she should be popping up in ours, Mr. Dillard. Okay, there she is, and we'll get you on your way, Mr. Dillard. So,
No, I don't want to just get on my way. I need to know what's going
no,
on.
hold on, Mr. Dillard. I know. So, Miss Underwood, we have Mr. Dillard here, and I know you're in the middle of Judge Oldsavers because I was watching you on YouTube. But Mr. Dillard was supposed to, so in the matter of the people of the state of Michigan versus William Jarrett Dillard, file number 23-21360 FCF, Rhonda Underwood appearing on behalf of Mr. Dillard. So, Miss Underwood, we recognize that Mr. Dillard has a couple misdemeanor cases. And yesterday, it looks like a Zoom hearing notice from the court wasn't sent to bring him back. So he wasn't able to appear in district court yet on these issues that are the same as the violation of probation. But Miss Underwood, I did call down to district court and they told me that you would advise them to expedite the matter as soon as possible. And so Mr. Dillard is going to have a district court Zoom pretrial on September 16 or September 16 at 8:30 in the morning. So based on that, I would like to set mine for September 17 at 8:30 in the morning. So that's only 2 weeks, Mr. Dillard. And then Miss Underwood will be there in district court on Tuesday and then on my court on Wednesday to try to resolve all this.
Okay, so does she know what's going on with my probation violation? Like, can she discuss that with me? What's going on?
Miss Underwood? Yeah, you've been arraigned, haven't you?
I know. I've talked to Ms. Walsh. I know that you are currently in prison on the parole violation. So, once this gets resolved, hopefully there'll be a situation where your time is running concurrent. That's what
it
I'm
can't
going
run
to
concurrent.
hope for.
It's got to be consecutive. He was on parole at the time of this offense. It would
Okay,
be
but I'm saying
consecutive.
I thought I got a suspended sentence. I thought I had a suspended sentence to do.
Yeah,
it would still be consecutive.
All right, but right now I'm trying to get re-paroled to my detainers and my warrants. That's why I'm trying to get this taken care of. I've already seen the parole specialist and I'm just waiting to get this cleared up so I can get paroled back to.
So, Mr. Dillard, the first thing you have to do is take care of the district court stuff, and that's set for September 16. And Miss Underwood will meet you there, and then on September 17, you'll come back in front of me. Miss Underwood, you have one more in front of Judge Olsaver, correct?
One or two.
All right, because I have a guy in the jail and Judge Olsaver's gray hair, beard, glasses. I don't know who he is. Is that yours?
Yes, Mr. Wright. Yes.
Yes.
Are you pleading him or just setting a pretrial?
I believe we're setting a pretrial.
Okay, why don't you head back to Judge Olsaver and take care of that? And then when you're done with Judge Olsaver, I'll give you a breakout room to talk to Mr. Dillard. All right?
Okay.
All right, so Mr. Dillard, just bear with us. Let her
Can
go
I
back
talk to my PO?
She's got to go back to
the other case.
She's got to go back with Miss Underwood to Judge Olsaver's.
Yeah, well, I don't want to. I'll talk to Underwood the next time, man. This shit is crazy.
You don't want to wait for Miss Underwood?
She's not gonna. How long? Another hour?
Where are you, Mr. Dillard?
RGC.
I'm in Jackson. RGC.
Okay. All right. Thank you.
All right, so
gonna
Mr.
see-
Dillard, do you want Miss Underwood just to set up a time to Zoom with you at RGC?
No, I want to talk to her when she's done.
Okay, all right, so, all right, go ahead, Miss Underwood, go back to Judge Olsaver. All right, so Mr. Dillard, I'm happy in the waiting room and she'll be back in a couple minutes, okay? All right, Mr. Castleberry and Mr. McCready.
We're off the record, right, Judge?